Hello, everyone. For folks joining, we'll get started in about 1 minute. Hello, everyone. Welcome to the Environmental Law Institute's event, Global Methane Regulation, Updates from COP28 and an Analysis of the New Regulations. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We have a fantastic program in store for all of you today, and we're so excited that you're able to join us this morning for it. I want to take a moment to thank our wonderful speakers for taking the time to join us today and prepare for this program. Today's event will be recorded and posted to the ELI website for members to view later. So if you're an ELI member, please check back to the event webpage in a few business days to find the recording. Audience questions at the end of the program, so please feel free to put your questions in Zoom's Q&A box as soon as you think of them. There's no need to wait until the end of the program. While the chat will be open for you to post your observations, please put any questions that you wish for our speakers to address in the Q&A box rather than the chat. I will now go ahead and turn things over to today's moderator, Barry Rabe. Barry is the J. Ira and Nikki Harris Family Professor of Public Policy at the University of Michigan's Ford School. He's also the Arthur Thurneau Professor of Environmental Policy with courtesy appointments in the program in the Environment, the Department of Political Science, and the School for Environment and Sustainability. You can find links to our speakers' full biographies on the event webpage. But for now, Barry, I will hand things over to you. Thank you all so much for being here today.
Thank you, Madison, and good morning to everyone. Thank you for all joining us. First of all, Madison, just a word of thanks to you, Sarah Viken, and your other colleagues at the Environmental Law Institute for organizing this and also for bringing together such a really diverse and engaging set of panelists. The timing for this conversation is very, very appropriate. And so hats off to you and colleagues at ELI for bringing this together. I just wanted to begin by offering just a few overarching comments, but then really turn things over one by one to each of our speakers. We'll just note, so interesting to think about the issue of methane and its evolution as an environmental and climate policy issue, especially in recent years. If one looks at media coverage in the US and globally on climate change, if one looks at published scholarship in the policy sciences and the social sciences, until recently, it would have been very easy to assume that all of climate change involved carbon dioxide. And yet that has really changed in important and significant ways, even during the recent COP meetings, for the economists to argue that the methane moment had arrived, and at one point to name methane as the word of the day. At COP, we heard things about the development of an oil and gas decarbonization charter, new developments related to the relatively new global mechanism to try to deal with methane, the Global Methane Pledge, new initiatives in the United States and a number of other countries, and also efforts by the European Union to begin to move toward a system of regulations on produced and imported oil and gas, linking methane considerations. So there's so much to weigh and think about as methane, particularly in the oil and gas sector, continues its move from relative obscurity to center stage in climate policy and deliberations. I also think an intriguing set of questions for our panelists to consider and each bring their own perspective is, can all the sorts of new policies that are being explored subfederally and nationally in the United States, other nations around the world, actually be not just adopted, but stood up, implemented, effectively designed, backed by a credible emissions release and monitoring and measurement system? This is not a new issue. As I've studied the politics of methane in the United States, I'm mindful that in the 1950s, the state of Texas declared methane and flaring a major policy concern and took regulatory steps to try to limit releases through flaring. In the 1980s, North Dakota used its tax structure, its very large extraction or severance tax, to formally add methane to its tax reach to try to drive down releases. Those and other early policies really struggled, even if they stayed on the books, to perform in an effective way. And so this question of how we design methane policy, not only create it in the first place, but try to make it durable, ask if it's effective, and whether or not the US is really now moving into a position of global leadership to create a model of other nations is an intriguing one to weigh and consider. And I think we're going to get some great perspectives on this. Finally, we just also note that methane, CH4, plays such a large role, especially in current levels of global warming. And yet, I do wonder why so much of our focus in terms of policy discussion is on methane that comes from the oil and gas sector, but we see far less engagement and perhaps progress, whether we're talking about coal, landfills, agriculture, or livestock. And so I might try to conclude toward the end in a conversation that's largely focused on energy sector and oil and gas, appropriately so, to think about some of the larger issues and whether there are any takeaways from what we're seeing in oil and gas that could ultimately move us forward in those other sectors. With those as introductory comments, I'm just delighted to turn to our group of panelists. I'll provide brief introduction for each one. First up today, we're pleased to welcome Tomas Carbonell, Deputy Assistant Administrator for Stationary Sources at the Office of Air and Radiation and EPA, a very, very busy place these days, always, but certainly now. Prior to joining EPA, Tomas served as an attorney in the U.S. Clean Air Program at EDF, the Environmental Defense Fund. And prior to that, worked with Van Ness Feldman on a range of energy and environmental policy legal issues. Tomas, welcome and delighted to turn things over to you.
Thank you very much, Barry, and thanks everyone for having me this morning. I'm really pleased to have this opportunity to speak with you today about the work that we're doing in the Office of Air and Radiation to reduce methane emissions, particularly from the oil and natural gas sector. I think, as you all know, methane is a really potent climate pollutant that EPA estimates is responsible for about 1/3 of the global warming we're now experiencing. And controlling methane also comes along with a range of other benefits, including reductions in health-harming pollutants that are often emitted with methane, as well as the conservation of valuable energy resources. And so the Biden-Harris administration really sees reducing methane emissions as an urgent priority, as well as a major opportunity, not just to achieve near-term climate progress, but also to protect public health, advance energy security, and generate economic benefits. Next slide, please. So under this administration, the U.S. has been taking bold regulatory actions and mobilizing resources to support ambitious global efforts on methane, including the Global Methane Pledge commitment that Barry mentioned in the opening remarks, to reduce methane collectively by 30% from 2020 levels by 2030. EPA's work to achieve reductions in methane from the oil and natural gas sector is a cornerstone of U.S. efforts, because the oil and natural gas sector is the largest industrial source of methane emissions in the United States. And over the last 3 years, we've been pursuing multiple steps under the Clean Air Act and at Congress's direction in the Inflation Reduction Act to secure significant reductions in methane emissions from oil and natural gas operations. That work began in November 2021 and December 2022, when EPA proposed regulations under Section 111 of the Clean Air Act to reduce methane emissions from new and existing oil and natural gas operations. We recently issued a final rule in December of last year, announced at COP28, that would sharply reduce methane emissions from these facilities. And I'll say a little bit more about that in just a few minutes. And then in the Inflation Reduction Act, which was signed into law in August of 2022, Congress really recognized and embraced this Clean Air Act rulemaking and built a 3-part framework of additional measures known as the Methane Emissions Reduction Program, or as we affectionately call it, the MERP, to complement the Clean Air Act regulations and ensure reductions in methane from this sector. That Methane Emission Reduction Program includes over $1 billion in financial and technical assistance to support methane mitigation and monitoring from oil and gas operations. It includes a directive to EPA to update and improve methane emissions reporting requirements for oil and gas facilities. And it also includes a waste emissions charge to incentivize reductions in methane emissions from high-emitting oil and gas facilities. So together, these efforts are really meant to reinforce each other and complement each other. And they also, we believe, strengthen U.S. leadership in methane reduction from this industry. And as I'll describe a little bit later on, EPA is really kind of poised to support U.S. leadership in this area through our partnerships, through our work internationally, to provide technical assistance and share some of the lessons learned from our own experience. So I'll just say a little bit more about sort of each of these prongs of EPA's work, starting with our work under the Clean Air Act to establish new regulations for methane from oil and natural gas operations. Next slide, please. On the regulatory front, as I noted, the Clean Air Act rule that EPA finalized in December of last year will significantly reduce emissions of methane and other harmful air pollution from oil and natural gas operations, including for the first time from existing sources nationwide. There are essentially, two major components to the rule. First, the final rule includes what we call new source performance standards under Section 111B of the Clean Air Act to limit emissions of methane and smog-forming volatile organic compounds from new and modified and reconstructed sources in the oil and natural gas sector. And as a second prong, it also includes what we call emission guidelines under Section 111D of the Clean Air Act, which essentially requires states to develop and implement plans to limit methane emissions from existing sources across the country. Taken together, the standards and guidelines in this final rule really kind of comprehensively address the most significant sources of methane at new and existing oil and natural gas facilities. And these standards really draw from and build on proven and cost-effective solutions that leading oil and gas producing companies and states are using and have committed to use to reduce this harmful pollution. Just a few features of the rule, among other things, the standards require owners and operators to minimize or avoid methane emissions from equipment like process controllers, pumps, storage vessels, compressors. It includes a requirement that owners and operators phase out over a 2-year period routine flaring of natural gas from new oil wells. And it includes requirements that owners and operators regularly monitor wells and compressor stations and centralized production facilities for leaks and to repair any leaks found. One thing that we're very excited about in this new rule is that the rule recognizes that we are really living through a period of incredible innovation when it comes to technologies for finding and reducing methane emissions. Everything from new satellite technologies to aerial monitoring technologies, continuous monitoring technologies. And we really crafted the final rule to kind of support and incorporate those technologies and remain relevant and keep up with that pace of innovation over time. The rule allows owners and operators to use advanced technologies to meet requirements to monitor for leaks, including the technologies that I mentioned. And it creates a pathway for owners and operators to use new innovative technologies as they develop while still meeting the rule's requirements. Another exciting feature of this rule is that it includes what we call a super emitter program that leverages data collected by expert EPA certified third parties to identify and remedy large leaks and releases that are responsible for as much as half of the methane emissions from oil and natural gas operations. We got a lot of feedback on our proposed rule in connection with the super emitter program, and we made some important changes in the final rule that provide a strong oversight role for EPA in that program to ensure that operators and the public have a high degree of confidence in the data that's being used and that the program operates with a high degree of transparency. This final rule reflects over 1 million comments that we received from a wide variety of stakeholders, including states, tribal nations, oil and gas companies, frontline communities, environmental and public health NGOs. And we really think that the final package, incorporates and reflects that input to arrive at a final set of requirements that will deliver significant climate and public health benefits and is also feasible and cost-effective to implement. Next slide, please. Just to review some of those benefits, the final rule is expected to avoid an estimated 58 million tons of methane emissions from 2024 to 2038. That's a nearly 80% reduction compared to what emissions would be without the rule. In 2030 alone, just to put those reductions in perspective, the rule would achieve reductions in methane that are equivalent to the annual emissions of 28 million gasoline-powered cars. In addition to those climate benefits, the rule will also achieve significant reductions in ozone-forming pollution that will have long-lasting benefits for public health, preventing up to 97,000 cases of asthma symptoms and 35,000 lost school days a year. We estimate that those climate and health benefits will be up to $98 billion from 2024 to 2038, or about $7 billion a year, and that's net benefits after accounting for costs of compliance. In addition, the rule would achieve significant recovery of natural gas that would otherwise have been emitted to the atmosphere, enough to heat nearly 8 million homes for the winter. Now, as I mentioned, the Clean Air Act rule that I've just described is just one part of what EPA has been doing to achieve reductions in methane from the oil and natural gas sector. And I'll now turn to just providing a bit more detail on some of the programs that Congress included in the Inflation Reduction Act and that we are also working to implement to work hand in hand with these new Clean Air Act protections. Next slide, please. The first is an important financial and technical assistance program under which Congress provided over $1 billion to accelerate the transition to no and low emitting oil and gas technologies, as well as to support methane monitoring and mitigation more broadly. EPA is partnering with the Department of Energy to administer this funding. And we actually just last year announced that the first round of funding, which is going to be distributed in the form of formula grants to states, have been awarded to 14 states. That was a total of $350 million in funding that will be distributed by states to help oil and gas well owners and operators voluntarily and permanently reduce methane emissions from low-producing conventional wells. As a follow-up to that, we are planning a second round of grants that will be distributed in the form of a competitive opportunity, and that we expect to be opened in the first quarter of this calendar year. And that competitive grant opportunity is intended to make funds available to a variety of stakeholders for mitigating and monitoring methane emissions, not just from low-producing wells, but other oil and natural gas operations as well and related activities. Next slide, please. A second piece of the three-part framework that Congress included in the IRA relates to methane emissions reporting from oil and natural gas operations. As required by Congress in the IRA, last August, EPA proposed changes to what we call Subpart W of our greenhouse gas reporting program. These are regulations that require owners and operators of oil and natural gas facilities to report their methane emissions on an annual basis, and which have been in place for some years. The proposed revisions that we're making under the IRA would improve the accuracy of reported emissions of methane, which not only will support implementation of the waste emissions charge, which I'll say more about in just a minute, but also will enable the public to better track progress in reducing emissions from oil and natural gas operations. Some of the things included in the proposal include proposed requirements to report methane from certain sources that are not currently covered under our existing Subpart W regulations. We proposed updates to certain reporting methods to reflect the latest available data on oil and gas facilities and their emissions. And we proposed new pathways for oil and gas facilities to report emissions that are based on empirical data, including through the use of advanced monitoring technologies. We're currently working through and reviewing comments on that proposal and intend to finalize the revisions later this year ahead of a August 2024 deadline that was included in the IRA, so that companies can begin implementing changes to their methane reporting practices starting in 2025. Next slide, please. The last piece of the IRA I wanted to discuss is the waste emissions charge. In the IRA, Congress directed EPA to collect a charge on wasteful emissions of natural gas from large oil and gas facilities that exceed certain emission thresholds that are specified in the Inflation Reduction Act. The waste emissions charge is intended to encourage the early deployment of available technologies and best practices to reduce methane emissions and other harmful pollutants while new Clean Air Act standards are taking effect. Earlier this month, we announced a proposed rule to implement the waste emissions charge. Among other things, that proposed rule addresses how oil and gas companies would calculate the waste emissions charge based on their emissions, and clarifies how companies can use flexibilities and exemptions that Congress provided in the statute, including an exemption from the charge for facilities that are subject to and in compliance with the new Clean Air Act rules, as well as provisions that allow multiple facilities that are owned by the same entity to net their emissions and thereby reduce their waste emissions charge obligations. So those are the three kind of IRA related pieces, which, as I mentioned, are really designed to kind of, were designed by Congress to work together with the Clean Air Act rules to ensure near-term reductions in harmful emissions. And we think that as a package, this set of measures that EPA is working to implement will advance the adoption of clean and cost-effective technologies, reduce wasteful practices, and yield a range of economic and public health and climate benefits. Can we turn to the next slide, please? And that brings me to the last topic, which is really that in addition to sort of all these benefits domestically, these actions, we believe, really kind of reinforce U.S. leadership in efficiency, improved performance of oil and gas operations, as well as the development and deployment of innovative technologies and practices. And EPA is really poised to support that leadership through longstanding international partnerships, which allow us to utilize the lessons and experience that we've gained through our own domestic regulatory and voluntary efforts to support global action. For many years, EPA has been partnering with the international community to share lessons learned on methane mitigation through the Global Methane Initiative, or GMI. Through GMI, we worked with over 45 country partners and hundreds of private sector partners to provide training and technical expertise and analysis to support ambitious methane action, not just in the energy sector, but also waste and biogas sectors. And that longstanding effort has only become more urgent and relevant as we've seen methane really take center stage in the global climate discussion and as countries have ramped up their commitments to address methane. Obviously, the Global Methane Pledge was an important step in that evolution. And I believe that 155 countries have now joined the pledge to date, representing about 50% of man-made methane emissions globally. And one thing that's really encouraging to see is that along with those commitments through the pledge, we are seeing major players step up to announce public commitments and actions to reduce methane. Barry mentioned that in November of last year, the EU agreed on its first ever methane regulations, which include monitoring and abatement criteria for domestically produced and imported fossil oil, gas, and coal, and a plan to establish a methane import standard by 2030. Also in November, China published a methane action plan, and the United States and China reaffirmed their commitment to share information on technical solutions and to cooperate on capacity building and policy discussions. And then at the COP in December, the United States, China, and the United Arab Emirates convened a summit on methane and other non-CO2 greenhouse gases, where governments and philanthropies in the private sector joined together to announce more than $1 billion in new grant funding for methane reduction, which more than triples current annual grant funding and will leverage billions in project investment in methane reduction. And then Barry also mentioned the Oil and Gas Decarbonization Charter, also announced at the COP, in which 50 companies responsible for 40% of global oil production committed to limit methane pollution to 0.2% of their production operations by 2030 and to achieve net zero operations by 2050, along with a set of specific measures to help reach those goals. So these are very exciting developments, and I think reflect the evolution of methane as a urgent priority internationally, and also I think are part of a pattern which we're seeing in which actions and commitments being taken within individual countries, and including the U.S., are helping encourage actions at an international level. So with that, I want to wrap up. Just thank you again for the opportunity to join you today to talk about EPA's efforts, and I look forward to the discussion.
Thank you very much, Tomas. Thanks for taking us through this kind of complex suite or menu of different policy approaches that the federal government is pursuing, as well as bringing in some of the international component here. So thank you. I'm pleased to next turn to Kyle Danish, who is a partner at Van Ness Feldman and is a leader in that firm's energy transition practice. Kyle is also a senior associate non-resident in the Center for Strategic and International Studies, their Energy and National Security Program. He serves on the editorial board of Carbon and Climate Law Review and just has widespread experience in legal and policy issues, cutting across issues of climate, energy, and environment. And so, Kyle, delighted to turn things over to you.
Thank you very much, Barry. It's a pleasure to join you today. I appreciate the invitation from the Environmental Law Institute to present today. I'm going to pick up from where Tomas Carbonell left off in describing the suite of federal methane policies to just talk about, which he, not surprisingly, very clearly described and summarized. I'm going to pick up to talk about some of the legal and compliance issues with those rules and policies that are the sort of conversations I'm having with clients and others, just to sort of illuminate those and get them out here for us all to talk about them. Next slide, please. So I'm going to start with the Clean Air Act regulations, the Section 111 rules, the new source performance standards for new sources, the Quad C standards that will apply to existing oil and gas facilities. So some legal issues to think about and consider with those rules. Deputy Assistant Administrator Carbonell brought up the Super Emitter Response Program, which is clearly a very important element of those rules. This is the program by which the agency is going to certify third parties that can sort of extend the monitoring and compliance assurance aspects of the rule by independently maybe through satellites or other things, monitoring for super emitter events, these very large methane emission events that occur at oil and gas wells, compressor stations, and other facilities. So this was I think a very controversial part of the proposed rule, because as formulated, these entities were going to have a much more sort of unmediated role in both identifying and naming potential violators. And I think this was a sort of independence and sort of deputization that people felt might be stretching at the boundaries of the legal authority of the agency to delegate. I think in the final rule, the agency sort of took over more of this program, so that super emitter response program reports will go more directly to the EPA, and action will be assessed and taken by the EPA in a way that I think puts that program a little bit back into a more confined box within the agency's authorities to delegate for help, which it can do. But I expect this will be something that will be likely explored through the sort of inevitable litigation that comes from these sort of programs. It may well be that more legal controversy applies not in the sort of challenge to the underlying rule, but in the case-by-case application of it, where there may inevitably be disputes where this sort of third-party entity is trying to do an attribution exercise, which is still pretty hard to do. I mean, I think these technologies are improving very rapidly, but to identify whose well within a basin was responsible for what could be a short-term but major event will still have some challenges. And if the agency is going to move forward to sort of enforce and hold entities responsible for violations, this will be an area where I expect there will be possibly more disputes. Tomas Carbonell also mentioned the use in the rule, the sort of integration of these advanced methane measurement methods. And this is really one of the very innovative things that the agency is doing in this rule. The technologies for monitoring, identifying methane emissions while still evolving are evolving very rapidly. And there are many reasons to believe that in a lot of cases, they will work much better than what the agency has even identified as sort of the underlying best system for leak detection here, which is primarily these handheld cameras. The abilities of satellites, aerial surveys, and continuous monitors to identify and sometimes measure leaks is very much improving. So it's a great move, I think, by the agency to establish a system that, and I should say, many operators are already using these technologies in the field and want to use them because they're oftentimes much more efficient than sending people out and about with handheld cameras. So the agency has created an avenue that allows for the improvement, rather the approval of these methods. And once approved, they can be used by any operator. So that is great. They've created some basic criteria for the approval in the rules and have set up a system by which these methods can be, people can submit essentially an application for use of these methods. Now, a big question will be, how long will it take for the agency to work through the approval process here, because there's great eagerness to use these methods as soon as possible, particularly for entities that have like new facilities for which this effectively is a compliance obligation from day one. The agency has in the rule something that essentially says if we take over 270 days to review a method, we'll let you use it conditionally, which is helpful, although it may put operators at such risk to be using something that then could be disapproved ultimately, that I'm not sure how many will take it up. But in any event, I think this is an area to watch because to be fair, it'll involve not only the approval of the methods broadly, but how they can be used in particular places, particular basins potentially, or under certain conditions. So a lot of the implementation of this rule, I think, will turn on how these advanced methods are brought into play. Next slide, please. I wanted to talk about the reporting program, the Subpart W revisions, and the implementation of the waste emissions charge, because these two really do go together. The Subpart W program will be essentially the accounting methodology that will be then used, or the way of measuring emissions, which will then be used for implementation of the charge. And I think for me, I'm not a technologist, but as I've sort of looked at the way all these rules fit together, I think it's important to understand that what's going on with the waste emissions charge is something somewhat different than the Section 111 rules. The Section 111 rules are mostly about replacing known leaky technology with better technology, eliminating routine flaring and putting in systems for leak detection and repair. So it's about like sort of chasing down leaks or avoiding them. At least on the face of it, the waste emissions charge is really about measuring methane emissions all year long and determining whether the facility is above a certain threshold. And I think that the agency is in a challenging spot here, because while advanced technologies are improving quite a bit, we don't have anything like a continuous methane emissions measurement technology. It just sits at the end of a complex facility and just measures emissions every minute of the day. So that means, unfortunately, that, and by the way, that seems to be what Congress in the waste emissions charge seems to be sort of contemplating would be available, because it's saying, we're going to charge this per excess ton charge, which implies like a pretty accurate measurement of actual emissions, and emphasizes that these methods should be empirical. So again, I think this puts EPA in a tough spot. It's still using within subpart W pretty heavily emission factors, which are essentially across the board estimates. If you have a particular type of component or technology at your facility, the emission factor says, we're just assuming it's emitting this much. No matter what's actually happening at your facility, no matter what part of the country you're in. So there's still a lot of use of emission factors. And these factors have been revised to be more conservative, because I think people found that the agency was just missing a lot of emissions writ large. So now they have to run this program, which sort of is supposed to tax people for every excess ton and using essentially a lot of estimations. And I think here, the agency, even within that construct, missed an opportunity to make more use of the measurement methods that are out there, some of which are, while not perfect for calculating minute by minute facility-wide emissions, are getting quite good at identifying leaks at particular components. So curiously, the agency just didn't really integrate all of these methods, which it sort of praised and involved in the Section 111 rules, into the subpart W regime, and instead used in some points assumed super emitting constructs instead. So I think there's a chance in the final version of this rule that the agency may recalibrate a little bit to at least bring forward the use of some of these advanced methods to let operators say, well, this is fine, your emission factor assumed this, but I've had a continuous monitor facing that component for the whole year, and it just didn't have a super emitter event or have that level of leakage. So I think that's something I'm looking for in the final version of the subpart W rule. And then on the the waste emissions charge implementation proposal, which came out recently, as Deputy Assistant Administrator Carbonell pointed out, it has some important exemptions in it that Congress created and that EPA has to interpret. One of which is this regulatory exemption that says, well, look, if you're in full compliance with the Section 111 rule, we'll excuse you from potential liability for this charge. But the language in the statute, which I think the EPA has interpreted appropriately, basically says it's only this exemption is only available when the Section 111 rules are in effect in every state where there are these facilities. So essentially, you have to have the whole thing roll out in the Section 111 program, which has this component of state plans that even the agency has estimated won't really be in place until sometime in 2027. The implication being that this charge could apply all the way into 2027 before there could be the availability of this exemption. Another issue that I've heard from operators is that the exemption is only going to apply not only when the rule is all in place, but only if your facility is 100% in compliance with the Section 111 rules, which may sound reasonable on its face, but there are a lot of ways to sort of foul up in a very minor way with slight deviations your complete compliance with the Section 111 rule, which would then knock the whole facility out for purposes of this exemption from the waste charge. Another thing to watch is how the agency implements another sort of feature of this waste emissions charge, which allows facilities under common ownership to net against one another. So if you have a facility that may be in excess of the relevant threshold, it could net against a facility that's below that threshold. The agency had to do a lot of interpretation of this particular netting provision in ways that I think ended up having it be pretty restricted. One is that common ownership and operation really is at like the owner of that facility. But the nature of this industry is that a lot of companies have business units that own different facilities and would like to roll things up for netting to the parent. But it doesn't appear that that would be possible under the way the EPA has proposed the rule. Next slide, please. I'll try to be quick about this, so this is a rich area. Of course, there are questions out there. Hey, could this set of rules and laws be rolled back or reversed in a subsequent less interested administration or less interested Congress? And of course, we've seen that happen before. I guess as I've thought through this and talked about it with people, it seems important to realize, and again, without making any predictions, that the methane policies that we've described here, the federal methane policies, are particularly well fortified, right? One is that even if you just look at the Section 111 rules, there's pretty good record of Congress actually telling EPA it has to do these rules. It has to do them somewhat in the way they've done it, by reaching existing facilities and et cetera. Congress rolled back the Trump EPA's effort to reverse these rules, the earlier version of these rules, and in doing so said, we want EPA to do a rule, we want it to reach existing facilities. There's a good bit of direction to EPA. Secondly, you've got a situation here where the Inflation Reduction Act created a whole sort of redundancy here, whereas even if you roll back the Section 111 rules, or even if you weaken them, you take away the regulatory exemption and the waste emissions charge applies, right? Again, not only if it's rolled back, but even if it's weakened, because one of Congress's conditions on the use of the regulatory exemption is that the Section 111 rules be no less stringent than the version that EPA proposed back in November 2021. So even weakening them, increases the risk that you're just subject to the charge endlessly. Now, of course, Congress could always just change the law, change the Inflation Reduction Act, take out the methane fee. But it's important to realize that that would require not only a anti-methane fee president, but also both a Senate and a House controlled by forces that would want to do that. So there's a lot, I would say an unusual amount of stickiness to these methane policies. Again, not predictive. Could they be weakened? Could they be rolled back? Could they be changed in the courts? It's all possible. But I think of all the rules that are out there sort of hanging out for attack, this one is potentially pretty sticky, this suite of methane policies. Thank you. I'm happy to hear from others and work through people's questions.
Thanks very much, Kyle, for providing a lot of context and a lot to think about on legal and compliance, and then even political issues as we think about in the US, standing up and bringing together these competing or even complementary policy tools to deal with the methane issue. Next, I'm very pleased to turn to Isabel Mogstad. She currently leads BP's Policy and Federal Government Affairs team. She oversees BP's legislative and regulatory advocacy with the federal government. And prior to that, she served in various roles, including a number of years at the Environmental Defense Fund. And she currently holds what I think is one of the more interesting titles I've heard in quite a while. She's also a Millennium Fellow at the Atlantic Council. Isabel, welcome. We look forward to your comments.
Thank you, Barry. And great to be with everyone this morning. It's always nice to go after Kyle and Tomas because they get to do all the hard stuff. So it's great to be with everyone. I think I'm going to just start with a couple high-level reflections and maybe even just some questions to put to the audience and to my fellow panelists that we can follow up on. You've heard, I think, a ton about the substantive details of the various policies and rules that are underway, principally, obviously, at the domestic level in the US. I think Tomas touched a bit upon international efforts, and I'll speak about those as well. I think my goal just for the next few minutes is just to level set from one industry perspective. And of course, there are going to be myriad and diverse perspectives within our industry on these various initiatives and how they come together. But I would offer that there are a couple of general themes that are converging in the policy space, and I think are worth discussing today and going forward. I think it's worth just level setting, though, on where we are with methane and how things are changing in this sort of dynamic political environment. You know, I think Barry may have opened with a few reflections on sort of the methane moment and why now, and the significance of this topic, the domestic and international stages. You know, I think I would offer that natural gas has an important role to play in the energy transition. It provides an affordable, secure, lower carbon source of sort of energy dense alternative to other hydrocarbons. And it has, over the last many years, contributed meaningfully to the US's achievement of its greenhouse gas emissions reduction goals, and is doing so internationally as well. But ultimately, there's sort of no debate, no question that unabated methane is really the Achilles heel of natural gas, and some of the benefits that are accrued to natural gas can be eroded if methane emissions are not only managed but minimized. The other dynamic at play is, you know, the U.S. has and recently has proposed and will finalize, you know, one of the strongest regulatory regimes for methane emissions globally, and that not only sort of aids the ability to maximize the climate advantages of natural gas as compared to some other energy dense alternatives, but really makes sure that we're realizing the full benefits of the other positive attributes related to natural gas more broadly. And I mention all of this because we now have this new political backdrop for the conversation today, which I think is important and ultimately shapes some of the conversations on the topic going forward, which is the new and very recent announcement from the White House sort of pausing the pending LNG export permits over at the Department of Energy. And I mention that because I think that does impact and change sort of the political landscape or the political backdrop as we talk about the importance of reducing methane across the oil and gas sector and sort of the ripple effects it has in global markets, in geopolitics and elsewhere, and all of this, and how all of this sort of ultimately converges. I think there's been a little bit of talk already about some of the progress that was made at COP28, and so I won't repeat sort of the substance of the numerous initiatives and details that have already been laid out. I will just note a couple of highlights that I think are particularly significant. There was mention of the oil and gas decarbonization charter, roughly 50 companies covering 40% of oil and gas production globally, with a heavy tilt towards national oil companies, as well as companies like BP and other publicly traded international oil companies. That charter is really focused on not only just sharing best practices and learnings, which is a key driver of change, but driving the industry towards net zero by 2050 or sooner, really gearing towards a zeroing out of methane emissions from the sector altogether, eliminating routine flaring, and greater collaboration again on technology, best practice sharing to reduce emissions. And those types of initiatives are absolutely critical. Similarly, we also had at COP28 the launch of a new global flaring and methane reduction partnership, which is housed at the World Bank. That is a $250 million multi-donor trust fund that's going to be aiding particularly developing countries with grants and technical assistance, as well as policy and regulatory advisory services and mobilization of additional financing from governments and companies to help these industries, help these countries drive down their methane emissions from the oil and gas sector as well. And I think it's important to note with something like this new fund, it's tied to similar programs that are going to keep everyone sort of accountable to a high bar. And that includes robust reporting and measuring of emissions through the Oil and Gas Methane Partnership 2.0, which is sort of a gold standard framework for measuring and reporting emissions. setting a goal of methane intensity of 0.20 by 2030 and continuing to keep the pressure on through the funding being contingent on zero routine flaring by 2030. And so many of these numbers, many of these goals, again, we're seeing all of them converge, both at the corporate ambition level. We share many of these targets as well in the regulatory space and now with these international initiatives. And I would just offer, sort of as we think about where we go from here, the vision is so important. The North Star is so important, but ultimately it's about implementation. 2030 is not that far away. Every year counts. So things like the oil and gas decarbonization charter, there's already work underway to formalize sort of the frameworks and governance of that new charter to ensure that progress is being made sort of quarter by quarter, not just in the run up to the next COP, but to achieve all of these ambitious goals by 2030. I think I just want to touch briefly on the regulatory side. And we've heard a lot about the substance and details of the numerous rules that we have now coming together in the US. And I think there are three themes that really stand out to me as we sort of assess these piece by piece and how they're ultimately going to come together. So one is timing. And we've heard about the regulatory exemptions for the waste emissions charge. We're waiting for the final subpart W, hopefully later this year, that will inform how we calculate our emissions to inform the charge. We are waiting to see the final 111 rules in the Federal Register and what comes from there. There is this open question about timing and how all of this comes together. And when you're sitting in an operator's seat thinking about long-term investment, having the regulatory certainty is a key enabler and sort of ingredient to investment decision making, and sort of the timing and clarity that we need to inform our business decisions is key, and something that we think about as all of these come together. Along that line, I would offer another key theme is simply harmonization, and I think Kyle did a great job at sort of talking about how these rules mutually reinforce each other, may in some instances create disincentives, but ultimately the goal is for these programs to harmonize in such a way that you have a streamlined methane reduction program in this country underpinned by well-designed policy and regulation that's clear, it's predictable, and ultimately it gives companies sort of the signal and rules of the road to go and make decisions for the long term. And then finally, I would offer as a theme something in the space around globalization, which is, and this comes back to sort of my comments at the beginning about our strong regulatory environment here, the new developments with LNG. At the end of the day, in addition to the important environmental outcomes that most of these policies and regulations are intended to deliver, there's also an element of this, which is setting the US natural gas industry up to be competitive for the long term. And we need our global partners to trust in the sort of climate efficacy and attributes of US domestic production, to have confidence in the numbers and the data that we are putting out. And so when we're having these broader conversations about new regimes, regulatory regimes in other countries, I think there's a recognition that what we are doing here is going to have significant implications for how we think about the role of US natural gas in global markets, and the importance of ensuring that global partners sort of have confidence in and access to the robust and lower methane supplies that we have here. So I will stop there, but I'll pass it back over to Barry and look forward to the discussion in Q&A.
Thanks very much. Thank you very much for that. Raising some really important issues on the industrial side, and some of the nice compliment to Kyle, some of the challenges, thinking about some of these important questions going forward. Finally, I'd like to turn to Romina Piccolotti, who has worked extensively on a range of short-lived climate pollutant issues, including hydrofluorocarbons and the Kigali procedures that are so important on a global basis. She is the Senior Policy Advisor for IGSD, the Institute for Governance and Sustainable Development, a founder of the Center for Human Rights and Environment in Argentina, and formerly Secretary of Environment and Sustainable Development for Argentina. Romina, delighted to have you with us.
Thank you, Barry. Can you hear me? Okay, great. Thank you, Barry, for moderating, and thank you for the Environmental Law Institute for organizing this. I think it's a very good and timely discussion. So I will begin, I don't know, we're running out of time, so I will begin by reminding everybody here why we're doing this, why methane is important. So, you know, methane is the only way that we can slow the rate of warming in the near term. There's a lot of science in the last years, robust science that basically is telling us that we cannot make it on climate if we do not reduce substantially methane. So it's the single most effective strategy to keep the goal of limiting warming to 1.5 within reach, while at the same time, as other speakers were saying, improving public health and agricultural productivity. Methane mitigation is also crucial to slow down tipping points and feedback loops. And this is very important for resilience, you know, for the communities that are more exposed to extreme weather events due to the climate emergency. So there's a human face behind what we're doing on methane mitigation. And I think it's important to remind everybody about that. The CCC, the Climate and Clean Air Coalition, which is an institution hosted by UNEP, put together the first global methane assessment and calculated that the strategy to cut methane emissions for 40 to 45% by 2030 could avoid nearly 0.3 degrees by 2040 and 0.5 in the Arctic, which is specifically important when we're talking about tipping points. You know, we know that if we lost the Arctic, is almost game over concerning climate. So 60% more than the global average, consistent with 1.5 scenarios, is what I'm talking about here. The IPCC report also put methane in the spotlight. The Climate Solutions Working Group report and 3, the ARC 3 as we know it, reinforced that deep and rapid cuts to methane emissions are essential to limit warming in the near term and shaving peak warming from overshooting 1.5. So what is required for us, for the whole world, basically, to go back to a safe zone on climate? So limiting warming to 1.5 with little or no overshoot requires us to reduce emissions by 34% below 2019 levels in 2030 and 44% below 2019 levels in 2040. And obviously these numbers, they change, and they will change according first to how effective we are in implementing these regulations to reduce methane, but also on how the climate system is reacting. So according to the CCC, currently available measures could reduce anthropogenic methane emissions from the energy production sector, the waste, and the agricultural sector, which are basically the main sources, by 45% by 2040, and roughly 60% of the available target measures have low mitigation costs, and just over 50% of those have negative costs, where the measures paid by themselves. So we have the science, we have the technology, and it's affordable, and it's the only way to reduce the rate of warming in the near term, which is essential to not only for lives, which is extremely important, but for everything that we value, you know, not only in natural terms, but on property issues, on economic issues. I mean, if we have a runaway climate, we know we will be in a global chaotic society. Next slide, please. So the world, little by little, have acknowledged this importance and have moved to voluntary commitments. And 187 countries already mentioned methane in their NDCs with a different degrees of ambiguity. As previous speaker has mentioned, the global methane pledge that really was done because of the leadership of the U.S. During the Biden administration, and the EU under their leadership. They rallied countries around the world to commit to to contribute to a collective effort to reduce global methane emissions at least 30% by 2030 levels. And also with the leadership of the US, dialogue with China began again on climate. And as a result, we have first in COP26 a joint statement that acknowledged the importance of working together on methane, and then the Sunny statement on the way to the COP, the month before the COP, where again methane was discussed, and China finally at the COP presenting their national action plan on methane. So I think that's very important, that these countries are collaborating on this issue and show the importance of methane itself. So also was mentioned here the Oil and Gas Decarbonization Charter. I will not mention that again. I mean, there are hundreds, of voluntary commitments by sectors, by institutions, by countries, by financial institutions. So I think we're in a good political momentum on voluntary commitments. The question is, will these voluntary commitments provide the necessary action at the scale that we need to slow the rate of warming on time? And there is where I think it's good to look a little bit closer to first what voluntary commitment has done on other areas, but also how we can move from, and most importantly, how we can move from voluntary commitments to a global mandatory framework. And please, next slide. So what else has happened? We have discussed here, regulations, national plans, China, US, Canada, European Union, Vietnam, Finland, Sweden, Norway, Netherlands, UK, Brazil, Iceland, Republic of Korea. They all have national plans already in place. Many countries are working on them, Egypt, Colombia, etc. We have the EU carbon border adjustment mechanisms that include methane, and obviously we have an impact on markets. The IRA that was discussed here, the Inflation Reduction Act, also an impact on markets. And we also have monitoring tools that we're discussing here, new ones, help from the sky, I call them, with satellites, Copernicus, IMEO, EDF-SAT, CalSat, there are some of them, and also on-the-ground monitoring and flights monitoring. So we're improving on every single aspect, Now, how do we move to a global agreement, and why does it is needed? Next slide, please. So what are the elements of a global methane agreement? First, we need a TEEP, which is a technological and economic assessment panel that will tell countries, based on experience, what are the best technologies available, the more economic one, the ones that can be deployed at the scale. And that has worked very well under the Montreal Protocol. And the CCAC put together the first ever technological economic assessment panel on methane and present that at the COP28. Then obviously finance is needed, and as was expressed before, during COP, $1 billion of funding was announced, including $400 million from the philanthropic community. But we will need a specific finance mechanism if we're going to move to a global methane agreement. And obviously we will need a scientific advisory panel the CCAC put together this global methane assessment through their own scientific advisory panel. So maybe we can migrate part of that to a new agreement. And obviously, we need to think very carefully on the governance structure of that agreement. Next slide, please. And when I talk about a global methane mandatory agreement, I know many people will be skeptical about this. But so I want to tell very briefly a story of success and why without that, these national efforts, what is extremely important and necessary to move towards a global methane agreement, will not be enough if we cannot craft as an international community together a mandatory agreement on methane. Next slide, please. And here I want to tell the little story that many people will know here about the Montreal Protocol. The Montreal Protocol is the most successful environmental treaty ever. And also, I say the most successful climate treaty, because while fixing the ozone, has delivered immensely for climate. We will have already lost our fight against global warming if not for the Montreal Protocol. So these two great minds, Sharon Rowland and Mario Molina, worked together, as you know, and they were the ones who discovered that the ozone layer was being destroyed by specific chemicals that we were putting out there. This was not easy work, they were ridiculized by economic interests that at that moment were making a lot of money out of these chemicals. There were disinformation campaigns, they lost grants for research, etc. It was not easy work, but the science their science was very strong. But it was not enough at that moment, to push the international community. And on the contrary, they received a big backlash. Next slide, please. And obviously, it was a lot of disinformation campaign. Some folks saying that the CFCs that were put in the atmosphere were not toxic, not corrosive, they were gray gases. Also, there was a lot of disinformation on the public that this was not dangerous at all. Next point, please. But then in 1985, we could not hide this anymore, and the whole world could see that it was a big hole on our roof. It was a big hole over Antarctica, and that was found by the British Antarctic Survey. Next slide, please. So it was a big reaction by the world, right? And what happened? The same that is happening now. National regulations began to take in place to phase out these chemicals. But soon the world realized that there will not be enough to put the ozone layer into the path to recovery, that we will need a global commitment to do so. And we negotiate that in an emergency mode, because it was an emergency. So in 1985, that was the British surveys came into the public eye. And in 1987, the world put together the Montreal Protocol. So it's not it's a very difficult task. I'm not saying that it's not, but it's something that we have done before and we can do for methane. Next slide, please. So at the beginning, there were only 86 governments, but the governance structure that it was constructed was such a good one that it built the necessary trust that governments could join and comply with specific schedules to phase out these ozone-depleting substances, and that there will be help under the process. And as a result of that, we do have, obviously, the ozone layer on the path to recover. Again, with voluntary commitments or national regulations, at that moment, we will not have been able to push the ozone layer back into recovery. So this is why also today we do need a global methane agreement. Next slide, please. And obviously, Mario Sherwood Rowland were, received the Nobel Prize for this in 1995. But Mario specifically did not stop there. With Turgot Saelke and Professor Anderson, they taught the world in an amazing campaign that we needed also to take care of HFCs, which is a super greenhouse gas, and the Montreal Protocol was amended to include HFCs as part of the Montreal Protocol, and now we have a specific schedule, a mandatory schedule on a super greenhouse climate gas to phase down HFCs under the Montreal Protocol. So we did it not once, we did it twice. We had global agreement on key issues, and specifically with target measures, enforcement measures, and compliance measures in place. As I said, the Montreal Protocol is a treaty that really, really works on the ground. So we can do that again, and I just will pause here to get everybody to think about and join us. I mean, we're obviously IGSD and the whole team is advocating for such an agreement and to begin discussions on such an agreement on methane. Thank you.
Thanks so much, Romina, and providing that valuable take on how we might think about the international dimensions of this, moving beyond the rather loose compilation of pledges and the like that we've seen, with the gold standard remaining Montreal and now Kigali in that important sector. I just would briefly, we've had a number of really great questions come in through the chat, and I wanted to share brief questions for each of our panelists, allowing for a little further dialogue. I've modified those to try to account for at least a few of the things that have emerged. And so if we might just go in order of the presentations, just a brief question and allow you to comment. First, Tomas, especially since you've sort of set the groundwork for us on the US landscape, heard reactions from colleagues. One immediate question that jumps out for me is the central role that state governments will be playing in many aspects of the state implementation plans and the like. And there's a history here, and there have been a wide range of state levels of engagement or non-engagement on methane. I'm mindful that the state of Texas just jumped in yesterday and has some real questions, not surprisingly, perhaps, about what is going on. And I'm just wondering how you see the role of federalism here, EPA engagement for states in all of the areas as you begin to stand this up, the SIP process, but more generally looking at states as partners, when historically, whenever the federal government has tried to move on methane, a lot of, if not most of the production states have seen it as the enemy and collided. Any thoughts that you'd like to share on that one?
Thanks for that question. I think as you're highlighting, the authority that we are relying on for the existing source portion of our Clean Air Act rule is Section 111D of the Clean Air Act, and it takes a kind of classic, cooperative federalism approach to regulation in which states are responsible for developing plans to establish and implement and enforce standards for existing sources. With EPA, approval and oversight. And so as we were developing our Clean Air Act rule, we had a lot of engagement with states about how that process should work and what their needs might be in that process. And we paid a lot of attention in our proposal and in the final rule to key issues like, deadlines, the kind of information that we were providing to guide the development of state plans, the kinds of information that states would need to provide in their submissions to us, and what criteria might need to be put in place for approving state plans. I think you also highlighted there's kind of like two different kind of considerations that were important to balance. One, we recognize that we got a lot of feedback during the rulemaking process about how important it was to provide clarity and certainty for states, particularly states that maybe don't have well-developed regulations in place as to what would constitute an approvable program. And so, in the rule, what we tried to do is provide a lot of detail about the standards that we would consider to be presumptively approvable for states, so that, if a state wanted to, it could essentially take the information that we've included in the rule kind of off the shelf and use that as the basis of an approvable, plan to regulate existing sources. But on the other hand, we also, heard from states that have already been regulating in this space for a while, or already have kind of approaches that work in their context. And while there are certain, constraints that we had to operate under, and when it comes to the Clean Air Act and the approvability of state plans, We did try to provide guidance on how we would evaluate existing state programs for consistency with our regulations and our guidelines, and also provided information about flexibilities that states have to consider factors like remaining useful life when they're developing their plans, and how EPA will evaluate those. And, regardless of what circumstances states find themselves in, we are committed to working with the states, every step of the way. Our regional offices throughout the country will be really kind of taking the lead in that process. And, we are planning to do a lot of engagement in the coming months as states start to begin that planning process.
Thank you, Tomas. Actually, Isabel, I think I'd like to turn to you next, if I might. In the case of my last question, I was talking about what do you do in a federal system where states take different positions, have different capacity and the like to deal with these issues. On the corporate side, you have massive firms, you have smaller firms that are all in the business of producing oil and gas, especially in a context as vast and as diverse as just the United States. And I'm wondering how you sort of see that large versus small producer in thinking about all the challenges here that have been discussed in terms of regulatory compliance, the charge and how that works out, but also this question of actually being able to generate from all of those producers reliable numbers, reliable, verifiable numbers on methane emissions after so many years where we have recognized that much of what emerges from industry and then government estimates of what those emissions are off by large orders of magnitude, and they tend to be in one direction. They underestimate the releases. How do you see that larger kind of industry coalition, recognizing that you're in competition with one another, but also recognizing that to be credible, all of these firms are going to have to work together and figure out ways to make all of this work?
Yeah, I'm happy to start that conversation. And I think I had seen a question in the chat that sort of nicely dovetails with this. Someone had asked about sort of what industry is doing and sort of why industry maybe is or isn't leading in this space. And so maybe happy to sort of sync those two questions of yours and the one from the Q&A. I think one of the things you're rightly pointing out, and maybe is the place to start, is it is important to recognize that industry is definitely not monolithic. It is extremely diverse, not only in the size of the companies, but also the geographies in which we operate, which ultimately does have a significant impact on what our emissions or carbon intensity profile might look like, the availability of infrastructure, the availability of electrification. So what a company like BP confronts in our operations and decarbonization goals might look and feel a little bit different to what other companies are experiencing. And to this point about why is industry either leaning in or in some instances leaning out, many of our companies, and BP certainly, sees reducing methane as a strategic advantage, a competitive advantage, the right thing, of course, to do for the environment, but also the right thing to do for our business. And so just to give an example of that, over the last several years, we have been implementing a $1 billion program in the Permian in West Texas to electrify our facilities, to take out infrastructure that was powered by natural gas and replace that with equipment that's either powered by electricity or air instruments. That requires significant investment, retrofitting of existing facilities, planning for new, innovative, new infrastructure going forward. It's required the build out of a $100 million substation out in West Texas that creates enough electricity that it could power, I think, something like 300,000 residential homes in Austin. We're using that because we need that investment to help drive electrification and ultimately lower emissions in our operations out in that area. We already have no routine flaring out in our operations. And I just use some of these as examples because industry is in different phases in our journeys to get to near zero methane emissions. And so Barry, back to your question about big versus small, we can talk about each individual company's sort of goals and objectives in this space. But then when it comes to the reputation of natural gas, both domestic domestically for sort of short to medium term and its relationship to the energy transition, and then this global macro conversation we're having about the role of US and global LNG and international markets. You know, a BP molecule is ultimately right now not distinguishable in a natural gas market from a smaller operator. So there's a collective good, reputational good situation, I think, at play that's important, which is it's in the collective interest of the natural gas industry to be a leader on methane, to drive down emissions collectively, to have a strong regulatory floor that establishes our industry as potentially sort of best in class then when it comes to sort of the global consumption of natural gas, and in some cases as LNG. And so, you know, I think the politics of the big versus small, they are real. I would just point out, for example, that with the waste emissions charge, and Kyle and others hold me accountable to this, I might get this wrong. I mean, you know, the key thing with the WEC is that there is a per metric ton threshold for companies that qualify or covered by the waste emissions charge. I think it's 25,000 metric tons. So if you're a company that reports less than that, you're not exposed to the program. And so I think there's a natural tension and perhaps dichotomy with big versus small that is important to recognize, but we also all benefit collectively from having these strong, well-designed regulatory programs.
Thank you. Thanks, Isabel. Kyle, if I might turn to you. The issue of LNG and the question of its future in the United States, the expansion, has been prominent in recent days, given the pause that's been outlined by the Biden administration. And I wonder if you can talk a little bit about what that step or steps like that might mean as we think about bringing in and trying to implement many of the regulations in the US, but also the diffusion of some of these, and with it, relating that to some of the questions that emerge in the chat related to natural gas and the future of natural gas and how we think about that as we think about this in a US context, but what happens when we export it elsewhere, and think about all of the other rules and provisions that link to that.
Yeah, I mean, with this pause that's underway that is going to allow the Department of Energy to sort of evaluate the increasing LNG exports in the United States and what the climate implications of those are and the geopolitical implications, at least on the climate side, I guess it seems to me one very simplistic way to look at it is what's being considered as sort of a supply side policy. What if we restricted the amount of LNG exports from the United States? Would that have some helpful climate impacts? And I guess that involves sort of a determination of what would people do who are using that US LNG now, what would they do, right? If you assume that the demand for energy in other countries is, all other things being equal, probably growing, they're going to substitute that with something. And I guess one possibility is they substitute with renewable energy. That'd be great. Or they substitute it with coal-fired energy, which I think would not be very good. Another possibility is that they just substitute it with LNG or gas from some other country, right? Because the United States may be the biggest exporter of LNG in the world, but it's still a relatively small percentage of the total natural gas that's being used in the world. It exports, the other exporters are about 80% of the rest of it. So it seems to me there's at least a possibility that what happens if you restrict US LNG exports is that you just get gas from other places. And I think this goes to what we've been talking about in the first hour of this, which is the EPA and the Congress are rolling out these policies that the EPA has determined will reduce methane emissions associated with US gas by 80% over the next few years. So that's going to significantly decrease the whole life cycle analysis of greenhouse gas emissions associated with US exports. If you just take US exports and restrict them, it seems to me it's just as possible that you're just going to have gas, you're going to get substitutes of gas from countries that just are not trying as hard on their methane emissions. So I think it's possible that you'll just have more methane intense gas substitute for the US LNG exports that are taken off the market. either more methane intense gas or coal, which I think is generally considered to be higher emitting from a life cycle analysis standpoint, but particularly once you've reduced methane emissions from US gas by 80%. So I think, again, this is a fuels analysis. I'm not an analyst of global fuels markets. I don't know how much you'll get from renewables, and I don't know what the substitution effects will be. But if you think it's at least possible that it would have that array of outcomes, then I think you have to take pretty seriously whether the US export of very low methane intensity natural gas, it could be a good thing for the climate in a lot of places.
Thank you, Kyle. Romina, to you, if I might. You raised the interesting model of Montreal and Kigali. And I've long thought that one key element there has been the issue of linking trade restrictions with regulatory provisions, mixing varying kinds of tools in unique ways. You also talked about carbon border adjustments being led by the European Union, facing an uncertain future. But I'm wondering how you might see the role of the United States in this, because going forward, the United States will be the only member of the G7 that has no price on carbon. But it'll become the first member of the G7 that, with the charge, will have a price on emission. The only other place where this is done, to my knowledge, is Norway in some form. Does that create a kind of momentum or leverage the pricing issue, or are we going to need to see other kinds of linkages to begin to move in the kind of direction that you're talking about on the multinational or global scene for methane? I think you're muted.
Yeah.
Thanks.
Thank you for the question. I think the US role on how the world will move on methane, we can see from the last 4 years, that is pivotal. So and I think you cannot isolate the discussion only to the US or to the G7. I think we have enough countries today with political momentum to sit at the table and plan how this global governance framework can take place. That also will respond a little of what some of the industry is asking for: certainty. As Isabel was saying, we need some certainty because these are investments a long term. So this is I think this is the good moment to at least ask the question, how our national efforts intertwine, and can we from these national efforts move to a regulatory framework, because we do know that voluntary commitments are not enough. You said that, Barry, at the beginning. We have been trying to do this for a long time and we have not succeeded. Well, we don't have more time. And the only option that we have is to succeed, because there is not another planet that we can move. So I think it is time to have these tough discussions that will lead the world to an enforcement mechanism, like a mandatory mechanism like Montreal. We can do this, but we will need the US at the table, obviously, as we will need China. And by the way, China did mention in their NDCs that they are in the National Action Plan, that they support an institutional international framework on methane, right? So I think they are seeing also that need in the near future.
Thank you. I have a long list of additional questions. There are lots of questions in the Q&A, some of which I've tried to incorporate here, but I also realize that we are running out of time for this. And so with this, I want to thank my colleagues. And Madison, I want to turn it back over to you.
Yes, thank you so much to all of our fantastic speakers for joining us today. Thank you to Barry for moderating, as well as to Tomas, Kyle, Isabel, and Romina for speaking. We so appreciate all of you taking the time and energy to make this program happen. Thank you as well to our audience for your time and engagement today. If you missed any part of today's webinar, the recording will be available to ELI members on the event webpage within a few business days. To find out more about the Environmental Law Institute's membership and other ELI programming, we encourage you to check out eli.org. And with that, I will bring today's webinar to a close. Thank you again, everybody, and I hope you have a wonderful day.